justice in an elected court system. Likewise, do you want to go against the opposing county or the opposing attorney on a civil case when you know that attorney's firm gave the judge the maximum amount for every person in that firm? Probably not. So, you know, that's one thing about elected judges that I think is very important. There's been a big push to change how the judges are selected at the Court of Appeals level, which was accomplished. And I think you will continue to see a push this year of either diminishing the capacity of the Supreme Court or changing the Supreme Court. You know, the Supreme Court Nominating Commission, or Court of Appeals Nominating Commission, was selected or was made up of lawyers and lay members of the public to go through the applications of those who wanted to be judge and go through that interview process, and then present 3 best candidates in their eyes to the governor, for the governor to then interview and appoint one of. Frankly, those in the state legislature in power aren't fond of that because they don't like not having some control over the people who are in those positions. And if you think it's just about, you know, not wanting lawyers involved in the system, I don't buy it. It's about controlling the outcomes of cases. The fact of the matter is half the people in the public are going to be upset when a judge makes a decision because it's a decision. And that's okay. That's what it should be. So,
Charles, years ago, and I'm not up to date on it, but Dr. Carl Menninger was given credit for sponsoring and promoting and getting the Reception Diagnostic Center established in Topeka. And that, as I understand it, became a model in the nation, credited to Dr. Carl Menninger. I don't know how much of that is actually true, but I know that that was the word from Dr. Menninger. And the function of the Reception Diagnostic Center was to take people before they went to the prison where they were sentenced and do an intensive diagnostic evaluation for two purposes. One, to determine if there was a basis of recommending that that person be returned to the county, to the district, for probation, or to develop a plan for his or her treatment if indeed they went to prison. Is that still in effect?
sort of. We have a regional diagnostic unit. It's at El Dorado now. And when somebody first goes in Kansas Department of Corrections system, they will go there.
All go there?
Yes, for essentially evaluation and placement. With the advent of the Kansas sentencing guidelines, the ability to turn around and send somebody back home isn't there anymore. You know, in the 90s, we went through this process called Truth in Sentencing. We were actually one of the early states in doing it. I believe Illinois might have been the first. And since then, the feds picked it up right after Kansas did. But we adopted it, I think, in '94. Because there used to be the indeterminate sentences. You know, you'd hear somebody convicted of robbery, they got 5 to 20. Means they serve 5, they could serve 20, somewhere in between. You know, I think when the RDU was around for those types of things, you know, you had a more input of, okay, hey, this guy can go back, because you had those indeterminate sentences. Well, frankly, the public didn't like indeterminate sentences, or at least those aggrieved by a defendant didn't like indeterminate sentences, so it makes it an easy pick for the legislature to say, yep, we're going to be hard on crime. So indeterminate sentences went out the window. The sentencing grid come in, so you have this truth in sentencing. And what it does is if you fall on that grid, you get sentenced to a certain sentence, you're going to serve at least 85% of that sentence. The rest of it's held out for good time and credit for your behavior. If your behavior is good, you'll serve 85, in some instances 80% of your sentence, then you'll be released on parole. If you mess up while you're on parole, you can be brought back in and to serve the remainder of that sentence or some other amount of time. So, lots of questions right here.
Yes. Could you explain bail? Who decides what bail will be?
Sure. Hang on just a second. Bail is actually decided by the judges. in one of two ways. For minor or lesser offenses, the judges generally have a bail schedule of if you commit X, your bail is going to be Y. For major offenses, there is no schedule. It's based upon the judge's discretion in setting a bond. Judges are controlled by statute in setting bonds, although, again, those are guidelines, if you will. A judge has to set a bond for everyone, no matter what you're charged with. And a judge has to set a bond with the idea of protecting the public safety and ensuring that the person will appear again for court. So if it is a crime where public safety is not concerned, which usually goes in hand whether or not the person will appear for court, bails are usually low. If it's a high-level crime, such as a murder or something like that, where the court feels like this isn't isolated and this person could be a danger to other people, it's going to be pretty high.
So bail is paid before conviction.
Yes, yes. Bail is a promise to appear for court. Otherwise, you're held in jail until your court time. But bail is your promise that you will show back up when you're supposed to.
Supposing, you know, I have to arrange bail, and I can show that I have $100,000 in stock. Would that, is there some way that would make me free?
Well, maybe. Bail is typically, there's usually two kinds of bail that, well, actually three kinds of bail that is granted. Or three methods of meeting your bail obligation. One is if the court puts you on an OR bond or recognizance bond, saying that based upon your promise to show back up, I'm going to release you. And it could be a $1,000 OR bond, meaning that if you don't show up, you're going to owe the court $1,000. So that would be your incentive to appear again. So that's one way of taking care of it. The other ways are, say it's a bond that you can't meet, then you're usually going to either have to put up your own cash or your own surety. And that's typically a surety is a bail bondsman. Bail bondsmen are usually backed up by either insurance proceeds or some other type of hard collateral. And they will typically come in and say, if you had a $100,000 bond, a bail bondsman will say, you're going to pay me $10,000 and I'm going to put up the $100,000 for you. So I'll be responsible for you. The $10,000 you'll never get back because that was your fee to them to put up the $100,000. Bail is an interesting thing. This is completely off topic, but the bail laws go back to the 1800s. And when somebody bonds you out and places up bail for you, you literally become their chattel. And they can come retrieve you wherever you're at. It's interesting, but the old bounty hunters literally carry the 1800s Supreme Court case in their pocket with them to say, look, they're my person, and I can take them. And they literally can. Yes.
I've had the good fortune to know some current as well as retired judges at different levels. One thing strikes me about each one that I've known well is that they have been humbled by practicing the law. Has that begun to happen to you in your position?
Sure.
What I've learned today is that my corollary, which I think is original with me, Murphy's Law is a good one, but my corollary to Murphy's Law is nothing simple ever was. And because things aren't simple, even though we'd like to make them simple, we get humbled with the complexity. I mean, it can drive you to drink almost.
Yeah.
It hasn't driven you that far, has it?
Well, I drink on occasion, but I can't say that that's the problem. No, you know, it is. It's a, you know, if I try, frankly, not to really stop and think about it, because I think it's kind of weird, if you will, to think about the power that you have in this type of position, or even a judge. The judge has power in a position. And really, you can drop that down to law enforcement or anybody else that has a position of power over others. It's humbling, it's scary, it's all those things, frankly, sometimes. Nothing gets you more, and you probably should get out if it doesn't, is when you have to make a decision in a case.
Charles, we've come to the point of conclusion, but do you have some time to answer any other questions if people wanted to stay around?
I'd be happy to.
Okay.
I wanna ask-
We want to thank you for being here and being so informed.
My pleasure. I can stay up here if you want to keep going for a little while, or I can come around, or however you guys want to do things.
Betty has a question.
Okay, yes, ma'am.
I wanted to ask one question that is not maybe a criminal case, but it could be. And that's the annoyance of these scam telephone calls.
Oh, yeah.
Should we report those to your consumer protection department, or do we just
Oh, yeah.
gulp it down and forget it?
Generally, no, because frankly, we couldn't handle all the phone calls. Because there's so many of them out there. If you think something, if it is something that you think has seemed to be effective or that you're unsure about, if it's a scam that you pick up the phone, you're like, man, this is a scam, I'm not talking to these people, and you know it right away, I really wouldn't be too worried about reporting it, because everybody else is too. The problem comes in when you start having questions. Well, maybe this is legitimate. That's when you ought to give us a call. When you're like, I don't know about this. Please call us on those occasions, because those are usually the times that we find out new scams are going around. It's something different. I wish I could say I've heard of all of them, but holy smokes, they come up with new ones every time you turn around. And, let alone if there's some national disaster or international disaster, the scammers are on the phone within minutes after that thing. Just really amazing. So if it makes you pause and question whether or not it's legitimate, go ahead and give us a call. We would like to hear that, because that gives us an opportunity to turn around and say, hey, we maybe need to alert the public on this thing, part of our educational process. Because when something new is going around, we try to be on top of it to let people know. Yes, sir.
I just had a question about grand juries. Where do they fit in, or do they at this level?
Great question. Grand juries. Grand juries are relatively new in Kansas. I mean, there's always been the power to impanel a grand jury, but it required the petition of the people, essentially, to do it.
So that would be somebody who thinks something needs to be tried that's not being tried?
Right. Some examples of that, there had been successful grand jury petitions in Shawnee, Wyandotte, and Sedgwick County, or Johnson County, on obscenity and pornography. Most of these came out of, I think, kind of the same church group that went through and said, hey, we want you to prosecute these shops that sell adult novelties and those types of things. And to get the prosecutor to do that, they signed up enough petitions that required the prosecutor to have to call a grand jury. Grand jury law was actually changed 1.5 years ago. Now that the district attorneys can call their own grand juries.
Yeah, that's what I heard recently, and they almost implied that was so the prosecutor wouldn't be held, for maybe trying to try something that shouldn't have been, or vice versa. It's
Right.
a way to kind of move it onto somebody else and say, I'm just handling that.
Well, you can surely use it that way. We have not convened one here. I know Shawnee County has convened several. And a lot of times when they have tough cases, what they will do is they will go present to the grand jury to decide if the grand jury says this case ought to go forward. Then if they say the case ought to go forward, I think that, they've used that as a shield a little bit, if you will, but also a useful tool
Yeah.
to say, hey, look, this group of people, the public, thinks this ought to be prosecuted. And so because of that, I'm going to go forward with this case. I can alleviate some of my discretion tree here and go forward with this case because the people have said this is something that they're interested in.
Well, it helps you be possibly objective in a case where you're maybe afraid you might be overly subject.
Well, yeah,
I'll just
that
give
would
it
be
to
a,
them and let the people
right,
decide.
that would be a tool. You know, everybody comes to the table with their own biases,
Yeah,
you know, and try to suppress them as much as you will. They're going to creep into what you do.
right.
You know, that's what we have to explain to juries all the time. Look, you know, you're a great person, but this may not be the best jury trial for you to sit on. Because there may be something in your past when you look at this case, go, man, I can't decide this case fairly because I know this. Or I've been through this. So, you know, if those types of things happen, you know, those creep into our system. But yeah, generally, grand juries can be a very good and useful tool.
How are judicial, professional ethics charges reviewed and resolved?
Disciplinary complaints against attorneys?
Correct.
Yeah, anybody can make a complaint to the disciplinary administrator's office by phone call, by writing, by complaint form. It goes to the disciplinary administrator's office. The disciplinary administrator is appointed by the Supreme Court, and their staff then reviews those complaints. If they look at it and on its face, they say, this isn't a complaint, this isn't an appropriate complaint, they will take care of it. If they think there's anything about it that could be an appropriate complaint, they will then send a formal letter to the attorney asking for an explanation. It may be docketed at that point, meaning that it's a formal request, or it may be not docketed and just an informal, please explain. Once that process go through, if they docket it, it will be assigned to an investigator. Investigators are usually other attorneys that have been, you know, approved either by the local bar or by the disciplinary administrator's office. I actually do it for prosecutors. I get complaints that are assigned to our state prosecutor, disciplinary administrator. It's not really the correct term for them, but they're started in charge of the state prosecutor's panel. And he assigns out cases. He'll call me up and say, hey, I've got this case in X county, prosecutors accused of doing something improper. I need you to investigate. We'll take the complaint, we'll go out and interview people, we'll investigate it through, interview the judge, witnesses, whatever we have, compile a report that will go back then to the disciplinary administrator's office. Then that report will be reviewed by a review committee, and the review committee will recommend penalties if they believe something's been done wrong.
Does that typically span over 3 to 6 months, or what?
Well, it can be longer than that, depending on what type of issue it is. I sat on a hearing panel last April, and this had progressed quite a ways through the process, because the investigation was completed, already been to a review hearing. Then they had a hearing on it in front of the review panel, and I was on the review panel. That was in April. Supreme Court just disbarred that attorney last week. So, you know, it can take several years sometimes.
Thank you.
Yeah. So, all right. I think that'll do it.